They built 100 houses on my land. Nobody asked me. The bulldozers came at dawn, engines roaring. My neighbors watched from their porches, stunned. I didn't scream. Morning. I just watched, and I smiled. The HOA president thought she'd won already. She had no idea what she'd just finished building. My name is Wade Colton, and I run cattle on 400 acres my grandfather homesteaded outside Comfort, Texas. My wife Renee and I raised 2 kids on this land, and every fence post out here carries a story older than the subdivision next door. Falcon Ridge Estates went up 6 years ago on the property line east of us. A gated community full of stucco houses and a homeowners association that treated its bylaws like scripture. I mostly stayed out of their business. That was my first mistake. The HOA's president, Deborah Whitlock, had a reputation before I ever met her. She'd gotten a family's above-ground pool condemned over a paint color violation and once sued a widow for hanging wind chimes. People in Falcon Ridge called her the sheriff behind her back. Deborah had chaired the board for 4 years running unopposed, mostly because nobody wanted the headache of fighting her. She kept a 3-ring binder of every violation she'd ever issued, color-coded and alphabetized, like a trophy case for other people's misery. The dispute started small. A 40-acre strip along our shared boundary had always been unclear on old county maps. A leftover sliver from when my grandfather sold part of the ranch to the original developer back in 1987. Nobody had ever bothered to survey it properly. I'd grazed cattle on that strip my whole life. My grandfather ran cattle there before me. There was a rusted gate with our brand welded into the ironwork. And everyone in the county knew that patch of scrub belonged to the Colton family. Deed or no deed, Deborah didn't care what everyone knew. She cared what a piece of paper said, and she'd found one that suited her. She started showing up at the fence line with a clipboard, taking photos, muttering about encroachment like she was building a case file against me personally. I tried to be neighborly about it. I invited her out to walk the property with me, offered to show her my grandfather's original 1962 survey stakes, still visible if you knew where to look. She declined. Had its own documentation. That should have worried me more than it did. Renee kept saying Deborah wasn't the type to let a maybe boundary go. Not when there was a chance to expand the subdivision's footprint and add a few more premium lots to sell. A month later, a surveying crew showed up on my side of the fence without permission, flags in hand, measuring wheels rolling across my grass. I asked them who sent them out. The foreman just shrugged and said, "The HOA hired us." Talk to Deborah. I called Deborah that evening. Made my skin crawl. All sugar and no substance. She told me the survey was just due diligence, and that Falcon Ridge was simply clarifying its property lines ahead of a planned expansion phase. I asked to see the documentation she claimed to have. She said she'd have her attorney send it over when appropriate. That phrase, when appropriate, became something I'd hear a dozen more times before this was over, always meaning never. Word around town moved fast. A rancher 2 properties over told me Deborah had been asking about my grandfather's estate paperwork at the county clerk's office, going back through public records like she was building a legal case rather than just curious. I finally drove down to the clerk's office myself. The clerk, a woman named Sylvia who'd known my family for 30 years, pulled me aside. She said someone matching Deborah's description had requested copies of an old 1987 boundary survey, the same one tied to my grandfather's land sale. Sylvia mentioned something odd. The copy Deborah requested wasn't the original filed survey. It was an amended version filed years later. One Sylvia didn't remember approving, with a signature that looked rushed compared to the clean penmanship on file from that era. I didn't think much of it at the time. I chalked it up to old paperwork and clerical sloppiness. I had cattle to move and a fence to mend, and I figured the HOA would eventually lose interest once they realized the strip wasn't worth the fight. I was wrong about that too. An official-looking letter arrived from Falcon Ridge Estates attorney, claiming the 40-acre strip had been legally annexed into the HOA's common area under an amendment passed by the board back in 2019. I'd never received notice of any such amendment. No mailer, no public hearing, nothing. When I called the county to verify, the clerk told me she had no record of an annexation filing for that parcel at all. Amended survey or not, Renee wanted to hire a lawyer immediately. I told her to hold off. Intended to push this before I spent a dime fighting a fight that might fizzle out the moment someone official looked closely at her paperwork. That patience turned out to be the smartest and hardest decision I made in this whole mess. Deborah didn't know I was watching. She thought silence meant surrender, and women like her mistake a man's calm for a man's weakness every single time. I started keeping a folder of my own, every letter, every photo of surveyors on my land, every phone call logged with date and time. My grandfather always said paperwork wins wars that guns can't, and I intended to have more paperwork than Deborah ever dreamed of. What I didn't expect was how fast this would escalate from paperwork to bulldozers, or how personal Deborah Whitlock's obsession with that 40 acres would turn out to be, rooted in something buried far deeper than a boundary dispute over cattle land. The letter I'd received was just the opening move. 3 weeks later, survey stakes with pink flags appeared across the disputed strip, and a construction sign went up near the fence line. Future home of Falcon Ridge Phase 3. Coming soon. I marched straight to the HOA's monthly meeting, uninvited but not illegal. Deborah sat at the head of a folding table like a judge presiding over a courtroom, gavel and all, a small wooden mallet she'd apparently bought just for this role. When I raised my hand and asked about the sign on my land, Deborah cut me off before I finished the sentence. This is a members-only meeting, Mr. Colton. Take it up with our legal counsel. The room went silent. A few homeowners exchanged uneasy glances. One older man, a retired teacher named Harold, actually spoke up and asked if the board had verified the boundary before authorizing construction. Deborah shut him down too, calling it old business already settled. I left that meeting angrier than I'd been in years, but angrier in the useful way, the kind that sharpens a man instead of blinding him. I drove home and called my cousin Danny, a real estate attorney in San Antonio who owed our family a favor or two. Danny listened to the whole story and went quiet for a long moment. Then he asked me to send him every document I had, especially anything with Deborah's signature or the HOA attorney's letterhead. He said something about the story not adding up the way it should. 2 days later, Danny called back sounding almost excited. The amended 1987 survey Deborah had used to justify the annexation had a notary stamp expiration date that, according to state records, wasn't even issued until 3 years after the survey was supposedly signed. That was twist number 1, though I didn't fully grasp its size yet. Somebody had backdated a document, and whoever did it hadn't been careful enough to check whether the notary in question was even licensed at the time the paper claimed. Danny told me not to confront Deborah yet. He wanted to quietly pull more records first, See how deep this went? Because forged documents rarely exist in isolation. If someone falsified one paper for a land grab, there was usually a pattern behind it. Meanwhile, the construction signs stayed up, and surveyors kept measuring my grass like they already owned it. I put up new no trespassing signs along the fence, photographed everything, and mailed certified letters to the HOA's registered agent demanding they halt all activity on the disputed strip. Deborah's response came fast, and it wasn't a letter. It was the county sheriff's non-emergency line, with a complaint that I'd threatened a survey crew. I hadn't. To leave and photograph their truck's license plate for my records. A deputy came out anyway, apologetic the whole time, clearly aware this was a civil matter dressed up as something urgent. He looked at my fence, my grandfather's old brand welded into the gate, and told me privately he didn't think I had anything to worry about. But Deborah wasn't finished escalating. She started a petition among Falcon Ridge homeowners, framing me as an obstructive landowner, blocking a project that would supposedly raise everyone's property values. Half the neighborhood signed it without ever walking the actual boundary line themselves. What none of them knew, and what I was just starting to piece together with Danny's help, was that Deborah wasn't merely defending a boundary. She had a financial stake in Phase 3 that went far beyond her role as an unpaid volunteer HOA president. Danny found it buried in a property record search. An LLC called Ridgeline Ventures held the development rights for Phase 3, and one of its 3 listed members was Deborah's maiden name, filed under a business address that traced back to her own house. Twist number 2. The HOA's interests. She stood to profit personally, directly, from every lot sold on land that legally belonged to my family. Land she was trying to seize using a survey document that appeared to be forged. I sat with that information for a long night, turning it over with Renee at the kitchen table. She asked the question that mattered most. If Deborah was willing to forge a survey and lie to her own neighbors, how far would she go to finish the job? We got our answer faster than either of us wanted. 2 mornings later, I woke to the sound of heavy machinery. Not surveyors this time, but excavators, already tearing into the topsoil along the disputed strip. Foundation stakes already driven into the ground. I called Danny in a panic. He told me to document everything. Call the county building inspector's office immediately, and under no circumstances go out there and confront the crew myself, no matter how much every instinct in my body wanted to. I stood at my fence line watching strangers dig up land my grandfather had grazed cattle on since before Texas paved half its highways, and I understood then that this wasn't a misunderstanding anymore. This was a calculated land grab, and Deborah intended to win by finishing before I could stop her. The county building inspector, a tired man named Roy Alvarez, came out within the hour, more out of routine than urgency. He checked the permit posted on site, a laminated sheet zip-tied to a stake, and frowned at it longer than I expected him to. Roy told me the permit listed the parcel number for HOA common land, not for the strip actually being excavated. Either someone had made a clerical error, or someone had filed a permit for one piece of land while building on another entirely. That discrepancy became my first real leverage. I filed a formal complaint with the county, requesting an immediate stop work order pending boundary verification. It wasn't guaranteed to hold, but it bought time, and time was the one thing Deborah couldn't afford to lose. The stop work order came through 3 days later, delaying construction just long enough for Danny to file a quiet title lawsuit on my behalf. forcing a court to formally determine who actually owned the 40 acres once and for all. Deborah didn't take the delay quietly. She called an emergency HOA meeting and stood before her neighbors practically shaking with fury, blaming me for sabotaging progress, and hinting darkly that my lawsuit was nothing but a greedy rancher trying to extort the association. Word of the lawsuit spread through Falcon Ridge like wildfire. Some homeowners started asking uncomfortable questions about why the board had authorized construction on disputed land in the first place, especially once whispers about the mismatched permit reached their group chat. Harold, the retired teacher who'd questioned Deborah at the earlier meeting, quietly reached out to me. He said he'd kept his own file of HOA meeting minutes for years, a habit from decades of faculty meetings, and offered to let me look through them. Buried in Harold's minutes from 2019 was a vote on the so-called annexation amendment Deborah claimed authorized the boundary change. Only 4 board members had been present, well short of the quorum required by the HOA's own bylaws to pass anything binding. Twist number 3. Her entire case on wasn't just legally shaky. It had never actually passed. She'd apparently recorded it as approved anyway, betting nobody would ever bother checking the fine print of a 4-year-old meeting. Danny filed that discrepancy with the court immediately, alongside the forged notary date and the mismatched permit. Individually, each problem might have been dismissed as sloppy paperwork. Together, they were starting to look like exactly what they were, a pattern of deliberate fraud. Deborah, sensing the ground shifting under her, changed tactics. She stopped talking about boundaries and started talking about community harmony, painting herself as a peacemaker being unfairly targeted by a bitter neighbor who refused to compromise for the good of Falcon Ridge. She even showed up at my property one evening, uninvited, standing at the closed gate with a plate of homemade cookies like this was a sitcom and not a fraud case. Renee answered the door and politely declined the plate, and Deborah, without another word, drove off. That visit unsettled me more than any lawsuit threat had. It meant Deborah understood she was losing ground publicly and needed a new narrative fast. One where she was the reasonable party and I was the stubborn obstacle standing between Falcon Ridge and progress. The stop work order held through the court's initial review, and a judge scheduled a formal hearing to examine the boundary dispute, the annexation vote, and the permit discrepancy together. Deborah's attorney requested a continuance, buying 2 more months before anything would be decided. I used those 2 months to keep digging with Danny. We pulled records on Ridgeline Ventures LLC and found the other 2 names attached to it, a local contractor named Gary Fenn and a developer from Austin named Marcus Doyle, who'd built 2 other subdivisions in the county. Marcus Doyle's name rang a bell for Renee. She remembered a news story from years back about a lawsuit against him involving a different HOA, where homeowners accused him of misrepresenting wetland boundaries to squeeze extra lots out of a development that legally shouldn't have existed. Twist number 4. Mind here. Not entirely. She was the local face of a scheme that Marcus Doyle had apparently run before, using a compliant HOA president to manufacture legitimacy for boundary claims that wouldn't survive real scrutiny. That reframed everything. Deborah wasn't just greedy or controlling by nature, though she was plenty of both. She was also, in some sense, a tool being used by a more experienced operator who understood exactly how to exploit a small town's trust in its institutions. None of that made what she'd done less serious. If anything, it made the case stronger, because it suggested a pattern of coordinated fraud rather than one HOA president's isolated bad judgment about a single, contested piece of land. Danny subpoenaed Ridgeline Ventures' financial records as part of discovery. Marcus Doyle's attorney fought it hard, which told us everything we needed to know about what those records probably contained, and how badly they wanted to keep them out of court. While the legal machinery ground forward, life on the ranch didn't stop. I still had cattle to feed, fences to mend on the parts of my property Deborah hadn't tried to steal yet, and a daughter's wedding to help plan that fall, regardless of who was suing whom. Renee kept telling me not to let this consume me, and she was right to worry. I caught myself lying awake some nights running through every version of how this could go wrong, picturing Deborah's lawyers finding some loophole that let the whole scheme slide through anyway. Then came a small, strange comfort. Sylvia at the clerk's office called me one afternoon, off the record, to say she'd found something odd while pulling more archives for Danny's request. An unrelated boundary complaint filed against Deborah personally, years before Falcon Ridge Estates even existed. Twist number 5. Similar once before, on a much smaller scale, disputing a fence line with an elderly neighbor in another county who'd eventually moved away rather than fight her. The neighbor's name was Eleanor Whitlock, Deborah's own mother-in-law. Sylvia said the file included a note about Eleanor accusing Deborah of altering a property survey to gain an extra half-acre of garden space. A petty dispute at the time, but one that showed this wasn't Deborah's first attempt to manufacture ownership out of paperwork. I didn't share that detail publicly. Not yet. Danny said it was more useful as leverage than as gossip. Something to hold in reserve in case Deborah's attorneys tried painting her as an innocent victim of an overzealous rancher during the hearing. Deborah, unaware of what we'd found, kept doubling down publicly. She sent another HOA-wide email accusing me of delaying vital infrastructure improvements and hinting that legal fees from my frivolous lawsuit might result in a special assessment charge to every homeowner in Falcon Ridge. That email backfired badly. Nobody in a subdivision wants a surprise bill for someone else's legal battle. And for the first time, homeowners started showing up at meetings specifically to ask Deborah-pointed questions about whether the board had proper legal grounds for any of this. Harold organized an informal group of concerned residents, not against the HOA itself, but against Deborah's handling of it. They requested an independent audit of the association's finances, curious whether Ridgeline Ventures had funneled any HOA dues toward funding Phase 3's construction costs. Deborah refused the audit request outright, citing board discretion, which only deepened suspicion among her own neighbors. For the first time since this began, I sensed the tide shifting, not because of anything I'd done directly, but because Deborah's own arrogance kept building her opposition for her. For a few weeks, things went quiet. The stop work order held. The lawsuit crawled through pretrial motions. And Deborah, oddly, stopped showing up at community events altogether. Some neighbors speculated she was simply lying low until the court hearing arrived. I let myself believe, briefly, that maybe this would resolve itself without further drama, that the paperwork would speak plainly enough for a judge to settle things quickly and I could get back to running cattle instead of chasing fraud through courthouse archives. Renee didn't share my optimism. She said Deborah wasn't the type to go quiet out of defeat. Women like that go quiet when they're regrouping, she told me, not when they're giving up, and I should enjoy the peace without trusting it. Danny used the lull to prepare thoroughly for the hearing, lining up Sylvia as a records witness, requesting the handwriting analysis on the backdated notary stamp, and formally entering Harold's meeting minutes into evidence to prove the annexation vote had never met quorum. My daughter's wedding came and went during that stretch. A bright, ordinary weekend that reminded me what all of this fighting was actually for. Watching her dance with her new husband under string lights on land my grandfather had cleared by hand meant more than any courtroom victory could. Deborah sent a card, unsigned but clearly from her, congratulating our family. Renee thought it was strange, almost desperate, like Deborah was trying to remind everyone she could still play the role of gracious neighbor whenever it suited her narrative. The quiet ended abruptly when Danny received the subpoenaed Ridgeline Ventures financial records. Buried in a spreadsheet of development costs was a line item labeled, "Consulting fee paid directly to Deborah Whitlock," dated the same week the fraudulent annexation vote was supposedly recorded. Twist number 6. Profit eventually from lot sales. She'd already been paid, months before construction even began. A direct cash incentive tied explicitly to securing the boundary in the HOA's favor by whatever means necessary. That single line item transformed the entire case. This was no longer a murky dispute about survey errors and clerical mistakes. It was documented, dated proof that Deborah had accepted money to manufacture legal cover for land that never belonged to Falcon Ridge Estates. Danny filed an emergency motion to introduce the financial records before the scheduled hearing date, arguing the evidence went directly to Deborah's credibility and motive. The judge granted it, moving the hearing up by 3 weeks instead of pushing it back further. I finally told Danny to loop Sylvia in fully and let her know how much her small tip about the notary stamp had mattered. She just laughed and said working the clerk's office for 30 years taught you that paperwork never lies, even when people do. Word of the subpoenaed records leaked somehow, probably through the court filing itself becoming public record. By the next HOA meeting, more than half the neighborhood showed up, and for the first time, Deborah found herself facing a room that wasn't automatically on her side. I didn't attend that meeting. Harold called me afterward and described Deborah standing at the podium, voice shaking, insisting the consulting fee was for unrelated landscaping advice, a claim so flimsy that even her most loyal allies in the room went quiet. The hearing date arrived on a gray, humid morning in late September. I wore my good boots and my grandfather's old belt buckle, the one with the Colton brand stamped into it, because if this was going to be decided by paperwork, I wanted the land's history sitting right there with me. Deborah arrived with 2 attorneys instead of 1, both from a firm in Austin, sharp suits against the courthouse's tired fluorescent lighting. Marcus Doyle sat behind her in the gallery, watching everything unfold with the flat, calculating expression of a man used to controlling outcomes. Danny opened by walking the judge through the timeline, the 1987 sale, the disputed 2019 annexation vote that never met quorum, the mismatched permit, and finally the backdated notary stamp that placed the amended survey certification 3 years before the notary was even licensed. Deborah's attorney objected repeatedly, calling the evidence circumstantial, insisting clerical errors happened all the time in small county paperwork. The judge allowed each piece in anyway, noting dryly that 4 separate clerical errors, all favoring the same party, strained credibility past its breaking point. Then Danny called Sylvia to the stand. She testified plainly, without embellishment, about the notary licensing records, about Deborah's earlier records request that didn't match the original filed survey, and about the discrepancy she'd flagged the moment she noticed it months ago. Deborah's attorney tried to rattle Sylvia on cross-examination, suggesting she held some grudge against Deborah personally. Sylvia calmly replied she'd never met Deborah before this case and had simply done her job, which landed harder in that courtroom than any accusation could have. Harold testified next, walking the judge through his personal meeting minutes from 2019, page by page, showing exactly which board members were present and which were absent, proving definitively that the quorum requirement in the HOA's own bylaws had never been satisfied. Deborah's attorney argued the bylaws' quorum language was ambiguous, a claim that fell apart when Danny produced the HOA's own governing documents, filed with the state, spelling out the quorum requirement in plain, unambiguous language that even a first-year law student could parse correctly. Then came the financial records. Danny introduced the Ridgeline Venture spreadsheet showing the consulting fee paid to Deborah, timed precisely to the disputed annexation vote. The courtroom went noticeably still as the judge studied the document for a long, uncomfortable minute. Deborah took the stand herself, insisting under oath that the payment was unrelated to Falcon Ridge business, purely personal landscaping consultation for Marcus Doyle's private residence. It was a claim nobody in that room, including her own attorneys, seemed to believe. Danny asked a simple question that broke the dam. If the payment was for private landscaping work, why did the invoice, entered into evidence, list the payment description as Boundary Consulting, Phase 3 Annexation? Deborah had no answer that didn't sound like a lie. I watched something shift in her face right then, the practiced composure cracking for just a second before she rebuilt it. It was the first time in this entire ordeal I'd seen Deborah Whitlock look, even briefly, like she understood she might actually lose. The judge called a recess before closing arguments, and during the break, Marcus Doyle's attorney pulled Deborah's legal team aside for a hushed, tense conversation in the hallway. Renee, watching from a nearby bench, said it looked less like strategy and more like blame already being assigned. When court resumed, something had changed. Deborah's attorneys requested a private conference with the judge, and afterward, rather than proceeding to closing arguments, they asked for a short continuance to explore settlement options with our side, a request the judge granted reluctantly. Danny warned me not to get overconfident. Settlement offers this late in a case usually meant the other side was trying to avoid a public judgment on the record. Not that they were suddenly interested in doing right by anyone they'd wronged. The first settlement offer arrived 2 days later. A modest cash payment for my inconvenience, combined with a quiet agreement that Falcon Ridge would keep the 40 acres and simply relocate the disputed lot slightly, framed as a compromise that solved nothing. I rejected it without hesitation. This was never about a payout. It was about a woman who'd tried to steal land my family had worked for 3 generations, using forged documents and a bribed vote, and I wasn't interested in letting her walk away from that quietly. Danny relayed my rejection, along with a counter, full recognition of my ownership over the entire 40 acres, immediate cessation of all construction, and a public correction from the HOA acknowledging the annexation had never legally passed. Deborah's team went silent for a full week. During that silence, something unexpected happened. One of the new Falcon Ridge homeowners, a young couple named the Reeses who'd already closed on a Phase 3 lot, reached out to Danny directly, worried and confused about what was happening to the house they just bought. The Reeses had recorded a phone call with Deborah months earlier, back when they'd asked pointed questions about the property line before closing. On the recording, Deborah could be heard reassuring them the boundary was 100% settled and nothing to worry about. Twist number 7. Or at minimum strongly suspected, The boundary was contested well before that call. Yet she'd sold false confidence to buyers moving their entire lives onto land she understood might not legally belong to Falcon Ridge Estates at all. The Reeses, terrified of losing their home to a title dispute they'd known nothing about, agreed to let Danny use the recording. They weren't trying to hurt Deborah. They just wanted the truth on record so their own home wouldn't get caught in the fallout. That recording changed the entire tone of negotiations. Deborah's attorneys stopped talking settlement and started talking damage control, aware now that consumer fraud claims from actual homebuyers could stack on top of the boundary dispute and turn this into something far larger than a land case. Marcus Doyle, sensing the walls closing in around Ridgeline Ventures, quietly retained his own separate attorney, distinct from Deborah's, a move that told anyone paying attention he was preparing to protect himself even if it meant letting Deborah take the fall alone. I found out through Harold that the HOA board itself was fracturing. 2 members, uneasy about the mounting evidence, called for an emergency vote to remove Deborah from the presidency pending the outcome of the lawsuit, the first serious internal challenge to her authority in years. Deborah fought the removal vote the way she fought everything, with threats and procedural objections. But this time her usual tactics didn't land the way they used to. Too many neighbors had already seen the financial records and the Reeses recording circulating informally through group chats. The vote to remove her from the presidency passed 6-2. A stunning reversal for a woman who'd run the HOA unopposed for 4 straight years. Harold, ironically, was appointed interim president, the same man Deborah had dismissed and silenced in that very first meeting. Losing the presidency didn't stop the construction fight, since Deborah's personal financial stake in Ridgeline Ventures existed independently of her HOA title. But it stripped away her institutional cover, and without the HOA's official backing, her position in the lawsuit grew visibly weaker by the day. Danny pressed the advantage, filing an amended complaint that now included fraud claims tied to the Reeses' recorded call, alongside the original boundary and forgery allegations. The stakes for Deborah personally had grown far beyond losing a piece of disputed ranch land. Renee asked me one evening if I felt any satisfaction watching Deborah's own neighborhood turn against her. I told her honestly that I didn't feel triumphant yet, just tired, and that I wouldn't feel anything close to satisfied until that bulldozed strip of land was legally mine again. Deborah, cornered and desperate, made her most reckless move yet. Rather than waiting for the court to rule, she quietly authorized Gary Fenn's construction crew to finish framing the remaining spec homes on the disputed strip, betting that completed houses would be harder for any judge to order demolished. I woke one morning to the sound of hammers again, faster and more frantic than before, crews working what looked like double shifts to close in walls and roofs before anyone could stop them. It was, I realized, a desperate gamble dressed up as progress. I called Danny immediately, furious that anyone would keep building on land actively under a stop work order and pending litigation. Danny checked the court filing and confirmed my fear. Technically, the stop work order applied only to new excavation, a loophole nobody had thought to close since the strip's foundations were already poured. Twist number 8. A genuine legal loophole, and rather than back down while a fraud case built against her, she chose to race the clock, betting that finished houses on the ground would pressure any judge toward a settlement instead of a demolition order. Danny filed an emergency motion to expand the stop work order to cover all construction activity on the parcel, not just excavation. The judge, clearly losing patience with Falcon Ridge's side of this case, granted it within 24 hours, but not before several more homes reached full framing. By the time the expanded order took effect, nearly all 100 planned homes on the disputed strip stood framed, roofed, and in various stages of interior finishing. Deborah had gambled everything on speed, and in a strange way, she'd actually won that particular race. What she hadn't considered, in her rush to finish before the law caught up with her, was what 100 completed houses sitting on stolen land would actually mean once ownership was formally, undeniably proven to belong to someone else entirely. Danny explained it to me over coffee one morning, almost laughing at the irony. In Texas law, improvements built in bad faith on someone else's land, especially with documented knowledge of a boundary dispute, generally become the rightful landowner's property once ownership is confirmed in court. In other words, every house Deborah rushed to finish, every roof shingled and wall framed in that desperate final sprint, was quietly, unknowingly, being built for me. She hadn't outmaneuvered the lawsuit. She'd potentially just handed her entire development over to the man she tried to rob. I didn't celebrate yet. Attorneys would fight that outcome viciously, arguing good faith improvement or demanding compensation for construction costs even if ownership landed in my favor. Nothing about this case had gone simply, and I doubted the ending would either. Meanwhile, the Reeses and several other Phase 3 buyers, now facing the terrifying possibility of losing homes they'd already moved furniture into, retained their own attorney and joined the case as concerned third parties, adding real human stakes to what had started as a boundary dispute. Their attorney argued Deborah and Marcus Doyle had knowingly sold homes on legally contested land without disclosure, a serious violation of Texas real estate disclosure law. Suddenly Deborah wasn't just facing me and the HOA anymore. She was facing her own homebuyers, furious and frightened, in open court. Marcus Doyle's separate attorney moved quickly to distance him from Deborah's decisions, arguing Doyle had relied in good faith on the HOA's assurances about the boundary. It was a thin defense, but a calculated one, aimed at leaving Deborah to absorb the worst of the coming judgment alone. Deborah, watching her own business partner maneuver to abandon her, reportedly grew erratic. Harold told me she'd shown up at a board meeting she no longer had authority to attend, demanding records access, until the new president had a deputy escort her out of the building. That image stuck with me for days. Deborah Whitlock, once untouchable, once feared, being walked out of the very meeting room where she'd humiliated a retired schoolteacher for daring to ask an honest question, now treated like a trespasser in her own subdivision. With her HOA authority gone and her business partner distancing himself, Deborah's next move crossed a line even her own attorneys hadn't anticipated. She began showing up near my property line at odd hours, sometimes alone, sometimes with a camera, photographing my cattle and my equipment for reasons nobody could explain. Renee spotted her first, parked on the shoulder of the county road one evening, watching our house through binoculars from her car. When Renee walked toward the vehicle to ask what she was doing, Deborah sped off without a word, tires kicking up gravel behind her. I filed a report with the sheriff's office, more out of caution than expectation of action. But it went on record, adding to a growing pattern that Danny said could matter later if Deborah's behavior escalated any further during an already volatile legal fight. It escalated 3 nights later. Someone cut the fence along our northern pasture, the one bordering Falcon Ridge, and 11 head of cattle wandered loose onto the county road before dawn. We spent hours in the dark rounding them up. One bull nearly clipped by a passing truck. There was no proof it was Deborah. Not yet. But the cut fence sat precisely along the disputed boundary. And the timing, 2 days after she'd been escorted from the HOA meeting, felt far too deliberate to dismiss as coincidence or random vandalism. Danny urged extreme caution, telling me any confrontation now could jeopardize the case. That Deborah's attorneys would love nothing more than an angry rancher giving them a public relations narrative to counter the fraud allegations piling up against their client. I installed trail cameras along the fence line instead, quiet and legal, aimed at the exact stretch that had been cut. Renee thought I was being paranoid. I told her paranoia had served this family well since the moment Deborah first showed up with a clipboard. The cameras caught something within the week, though not what I expected. Not Deborah herself, but Gary Fenn's construction truck, parked near the cut fence line late at night. A figure moving along the boundary with wire cutters visible under the dome light. Twist number 9. At all. But someone connected to Ridgeline Ventures, possibly acting on her instructions or possibly trying to sabotage the case in a way that could be pinned entirely on me if I'd reacted with anger instead of caution. Danny turned the footage over to the sheriff's office immediately, and it became part of both a criminal vandalism investigation and supplemental evidence in the civil case, showing a documented pattern of intimidation connected directly to people financially tied to the disputed development. Deborah's attorneys tried to argue the footage was irrelevant to the boundary case, unrelated harassment at worst. The judge disagreed, noting that intimidation against a party actively in litigation over the exact same parcel spoke directly to consciousness of guilt on the defendant's side. Gary Fenn, faced with a criminal vandalism charge and clear video evidence, did exactly what desperate men in over their heads tend to do. He hired his own attorney and began quietly cooperating with investigators, hoping leniency in exchange for information about who'd actually given the order. What Gary revealed stunned even Danny. He claimed Deborah had personally instructed him to create problems for me during the case, vague enough to deny later, but specific enough that Gary understood exactly what kind of problems she meant when she said it. Twist number 10. And the one that finally sealed Deborah's fate beyond any settlement her attorneys could negotiate. This wasn't just fraud and forged paperwork anymore. It was witness intimidation, property damage, and a documented pattern of escalating, increasingly reckless behavior from a woman who refused to accept she'd lost control. The district attorney's office, already aware of the civil case through local news coverage, opened a formal criminal investigation into Deborah, examining the forged notary stamp, the bribery-adjacent consulting fee, and now the fence-cutting incident as part of one connected pattern of conduct. Deborah's attorneys, facing both a collapsing civil case and a looming criminal investigation, finally advised her to accept whatever settlement terms she could. Still negotiate before things got dramatically worse for her personally, regardless of what happened to Ridgeline Ventures or Falcon Ridge Estates as a whole. I told Danny I wasn't interested in a quiet settlement anymore, not after cut fences and loose cattle on a county road at night. I wanted this decided in open court, on the record, where every neighbor who doubted me could see exactly what Deborah Whitlock had done. Renee worried the drawn-out fight was taking a toll on me, and she wasn't wrong. But something had hardened in me since that night rounding up cattle in the dark. This wasn't about the 40 acres anymore. It was about making sure Deborah couldn't do this to anyone else. The Reese's attorney, meanwhile, pushed hard for the buyer's claims to be resolved alongside mine, arguing it made no sense to litigate ownership of the land separately from the fate of the 100 houses sitting on it, waiting for a decision that would determine everyone's future at once. The judge agreed to consolidate the cases, setting a final hearing date that would resolve boundary ownership, the fraud allegations, and the homebuyer's disclosure claims together. A single sweeping decision that would determine who actually owned Falcon Ridge Estates' entire Phase 3 development. In the weeks before that hearing, Marcus Doyle's attorney reportedly reached out to Danny privately, exploring whether Doyle could negotiate a separate deal, distancing himself entirely from Deborah in exchange for cooperation, essentially offering to testify against the very partner he'd built this scheme with. Danny relayed the offer to me without recommending either way. I told him I wasn't interested in protecting Marcus Doyle from consequences either, but if his testimony helped prove the full scope of the fraud, I wasn't going to stand in the way of using it. Doyle's testimony, once formalized in a sworn deposition, filled in the last major gap in the story. He admitted the boundary dispute had been manufactured deliberately, that he and Deborah had discussed the disputed strip's development potential years before the fake annexation vote was ever recorded. He also admitted, almost offhandedly, that the backdated notary stamp had been Deborah's idea specifically, sourced through a contact of hers, someone who owed her a favor from an earlier, smaller land dispute, one Doyle said involved some family member of hers. That detail confirmed what Sylvia had found months earlier about Eleanor Whitlock, Deborah's own mother-in-law, and the earlier boundary complaint. Deborah had learned this exact playbook years before Falcon Ridge Estates existed, refined it, and simply scaled it up when a bigger opportunity presented itself. Danny entered Doyle's deposition into the record, and combined with Gary Fenn's cooperation, the trail camera footage, the financial records, and Sylvia's original notary discrepancy, the case against Deborah had grown from a boundary dispute into a documented, multi-year pattern of calculated fraud. Deborah, isolated now from her business partner, her contractor, and her own HOA board, reportedly spent those final weeks before the hearing almost entirely alone. Harold said she'd stopped attending community events altogether, her house sitting dark most evenings when neighbors walked past. I felt something unexpected during that stretch. Not quite pity, but something adjacent to it. Renee reminded me not to soften too much, that everything Deborah had done, the forgery, the bribery, the cut fence, had been deliberate choices made by a grown woman who understood exactly what she was doing. She was right, of course. Whatever loneliness Deborah felt now was the direct, predictable result of decisions she'd made herself. Starting from the very first moment she decided a 40-acre strip of Colton land was worth forging documents over rather than simply walking away from. The final pretrial conference arrived with an unexpected development. Deborah's remaining attorney filed a motion to withdraw from the case entirely, citing irreconcilable differences with his client. A polite legal phrase that Danny said usually meant a client had stopped listening to reasonable advice altogether. The judge granted a short delay for Deborah to secure new counsel, but made clear the final hearing date wouldn't move again regardless. Deborah, for the first time in this entire saga, would be walking into a courtroom without the polished legal team that had shielded her thus far. Renee and I drove past Falcon Ridge Estates the week before the hearing, past the 100 framed and finished houses standing empty under a gray Texas sky, driveways poured, landscaping installed, Not a single family able to move in while ownership remained legally undetermined. It struck me then how thoroughly Deborah's greed had backfired on everyone. Not just on me. 100 houses sat finished and worthless. Buyers like the Reeses trapped in limbo. An entire subdivision's reputation tangled up in fraud. All because one woman refused to accept a boundary she couldn't legally claim. Dani prepared relentlessly in those final days, organizing every piece of evidence chronologically. The backdated survey, the failed quorum vote, the consulting fee, the Reese's recording, the cut fence footage, Gary Fenn's cooperation, and Marcus Doyle's deposition. Complete, damning timelines spanning years. The night before the final hearing, I walked the disputed strip alone at dusk, past the finished houses, past the rusted gate with my grandfather's brand still welded into it, and felt, for the first time in this entire fight, something close to certainty about how this would end. The morning of the final hearing, the courthouse parking lot filled faster than I'd ever seen it. Word had spread through the county, and beyond Falcon Ridge Estates, that something significant was about to be decided. Part land dispute, part fraud trial, part small-town spectacle nobody wanted to miss. Deborah arrived alone. Her new attorney, a young associate clearly unfamiliar with the case's full history, hastily briefed and visibly overwhelmed by the volume of evidence Dani had compiled over the preceding months of relentless, methodical investigation. Marcus Doyle didn't attend at all, having already submitted his deposition and reportedly reached a separate settlement with the Reeses and other Phase 3 buyers, effectively cutting himself loose from Deborah entirely and leaving her to face the consequences alone. Gary Fenn appeared as a witness under a cooperation agreement with prosecutors. Visibly uncomfortable, avoiding eye contact with Deborah as he took the stand. A stark contrast from the confident contractor who'd once dug up my land without a second thought about who it belonged to. Sylvia testified again, this time walking the judge through the full timeline of notary licensing records, confirming beyond doubt that the certification on the amended survey couldn't possibly have existed on the date it claimed. A forgery plain enough for anyone in that courtroom to understand. Harold followed, calm and precise as ever, laying out the failed quorum vote in exacting detail. The same meeting minutes he'd kept out of old habit. Evidence that ultimately dismantled the entire legal foundation Deborah had built her annexation claim upon from the very beginning. The Reeses testified about their recorded phone call, their voices tight with the exhaustion of 9 months spent afraid they'd lose the home they'd worked their whole lives to afford, describing Deborah's false reassurances with a quiet, controlled anger that landed harder than shouting ever could. When it came time for Deborah to testify, her new attorney tried repeatedly to steer her toward careful, measured answers. She couldn't hold the line. Gary Fenn's cooperation testimony about the fence-cutting instruction. She grew flustered, contradicting her own earlier statements within minutes. Dani pressed harder, walking her through the consulting fee invoice line by line, the timing of the payment against the fraudulent annexation vote, and finally Doyle's deposition confirming she'd sourced the backdated notary stamp through a personal contact tied to an earlier family land dispute. Deborah's composure, the same icy confidence that had once silenced Harold at a folding table with a gavel, finally broke completely on the stand. She admitted, haltingly, that she'd known the boundary was contested before authorizing construction, though she insisted she'd believed the amended survey was legitimate. Dani asked the question that ended any pretense of ambiguity. If she believed the survey was legitimate, why had she personally paid to have a mother-in-law's decades-old family land dispute quietly resolved using the exact same notary contact years before Falcon Ridge ever existed? Deborah had no answer. So complete I could hear the air conditioning humming overhead. Watching a woman who'd spent years wielding paperwork as a weapon against her neighbors finally run out of paperwork and words to protect herself with. The judge called a brief recess before closing arguments, and during it, Deborah's young attorney was seen speaking urgently with the district attorney's office, likely exploring whether any cooperation now might soften the criminal charges already building against his overwhelmed, thoroughly exposed client. When court resumed, closing arguments were brief. Danny methodically summarized 9 months of evidence: forgery, a failed quorum vote, bribery disguised as consulting fees, witness intimidation, and a documented pattern stretching back years, all converging on one unmistakable conclusion about who this land legally belonged to. Deborah's attorney offered little in response beyond asking the court to consider that the disputed houses represented significant, innocent investment by third-party buyers, a plea for leniency in the remedy that had nothing left to say about his own client's underlying conduct. The judge took the matter under advisement rather than ruling immediately, promising a written decision within 2 weeks given the case's complexity and the number of interconnected claims involved. From boundary ownership to fraud to the fate of 100 finished, empty houses. Those 2 weeks felt longer than the entire 9 months preceding them. Renee and I tried to keep our normal routine: cattle to feed, fences to check. But every phone call made my stomach drop with the possibility that it might finally be Danny with news. Local news picked up the story properly by then. A reporter from the San Antonio paper driving out to interview me at the ranch, photographing the rusted gate with my grandfather's brand still welded into it. The same gate Deborah had once dismissed as irrelevant sentiment. The story ran under a headline that made Renee laugh for the first time in months. Rancher fights HOA over 40 acres, uncovers years of fraud instead. It wasn't the ending yet, but it felt, finally, like the truth was catching up to Deborah in public. Falcon Ridge Estates homeowners, reading the coverage, grew increasingly furious, not just at Deborah, but at a board and a system that had let one woman's ambition put 100 families' housing dreams and their own community's reputation at such reckless, avoidable risk. Harold, still serving as interim HOA president, called a community meeting to address the coverage directly, promising full transparency once the court ruled, and formally apologizing on the board's behalf to the Reeses and every other Phase 3 buyer caught in the fallout. Deborah, meanwhile, had reportedly put her own house up for sale quietly, a detail Harold mentioned almost in passing, unsure whether she was preparing to leave the county entirely or simply trying to raise cash ahead of whatever judgment the court might hand down against her. Danny warned me the ruling, whenever it came, might not be simple. Courts sometimes split remedies, awarding land ownership one way while ordering compensation the other. And he didn't want me walking into the decision expecting a clean, total victory on every single claim. I told him I understood. But privately, I found myself hoping for exactly that anyway. A full and complete acknowledgement that the 40 acres, and everything built on it, belonged to my family, the same way it always had since my grandfather first drove fence posts into that ground. The morning the ruling arrived, Danny called before I'd even finished my first cup of coffee. His voice steady but unmistakably excited in a way 9 months of careful legal caution hadn't allowed him to sound before, and I knew before he said a word that it had gone our way. The judge's written decision ran nearly 40 pages, methodically dismantling every fraudulent piece of Deborah's case. The forged notary stamp, the failed quorum vote, the bribery-disguised consulting fee, and the documented pattern of intimidation, concluding unambiguously that the 40-acre strip had always legally belonged to the Colton family, because the houses had been built in documented bad faith. With clear evidence Deborah and Doyle knew the boundary was contested. Texas law's improvement doctrine, applied exactly as Danny had once predicted over coffee months earlier. The finished homes became my property, not Falcon Ridge's, and not Ridgeline Ventures. 100 completed houses, framed, roofed, and landscaped in Deborah's desperate rush to beat the courts, now legally belonged to me, standing on land my grandfather had grazed cattle across for 60 years, transformed overnight from a boundary dispute into the largest asset our family had ever owned. The ruling also referred the notary forgery, the consulting fee, and the fence-cutting incident directly to the district attorney's office for formal criminal charges, separate from the civil judgment, meaning Deborah's legal troubles were only just beginning even as the property case closed decisively against her. I drove out to the disputed strip that same afternoon, past the rusted gate with my grandfather's brand, past 100 empty houses that had been built to steal my family's land and instead become the very proof of who that land truly belonged to all along. Renee met me out there, and we walked the property together in silence for a long while, taking in driveways and roof lines that represented 9 months of forged documents, cut fences, and sleepless nights, all of it finally, undeniably resolved in the Colton family's favor. News of the ruling reached Falcon Ridge Estates within hours. Harold called an emergency meeting, and this time the room was packed. Homeowners desperate to understand what the decision meant for their own properties, their HOA dues, and the fraud-riddled Phase 3 development next door. The Reeses, whose home sat directly on the newly confirmed Colton land, faced an agonizing situation, having purchased in good faith a house that legally now belonged to me, entirely because of Deborah and Doyle's fraud rather than any wrongdoing on their own part. I'd already told Danny, weeks earlier, that I had no interest in evicting families who'd been deceived the same way I'd nearly been. Once ownership was confirmed, I offered the Reeses and every other good faith Phase 3 buyer a fair, direct purchase option for their homes at reasonable market rates. That offer surprised the courtroom press covering the story more than the ruling itself had. Local news ran a follow-up piece describing it as the rancher who'd been wronged choosing decency over vengeance. Though honestly, it felt less like generosity and more like simple common sense to me. The Reeses accepted immediately, relieved beyond words to finally have a clear, legitimate path to owning the home they'd already moved their lives into. Most of the other Phase 3 buyers followed within weeks, grateful for a resolution that didn't leave them homeless because of someone else's fraud. Within 2 months, nearly all 100 houses had new, legitimate deeds, purchased directly from the Colton family at fair prices, transforming what had been Deborah's fraudulent land grab into a legally sound, honestly built neighborhood that simply happened to carry my family's name on every closing document. Marcus Doyle, having already distanced himself through his separate settlement and cooperation, avoided the worst of the criminal exposure, though his development company's reputation collapsed anyway once local news outlets connected his name to 2 separate HOA fraud schemes across different counties. Gary Fenn's cooperation earned him a reduced charge for the fence-cutting incident, community service and probation rather than jail time, though his contracting business never fully recovered once word spread through the county about his role in Deborah's scheme against a well-respected local family. Deborah faced the harshest consequences of everyone involved, exactly as the evidence warranted. The district attorney charged her with document forgery, bribery, and witness intimidation, on top of the civil fraud findings already entered against her in the property case Danny had built so carefully. Her house sale, turned out, hadn't been preparation to leave quietly at all. Danny learned through the criminal proceedings that Deborah had been liquidating assets to cover mounting legal fees, the same fees that had once funded expensive Austin attorneys now abandoning her one by one. At her arraignment, Deborah appeared without any attorney at all initially, unable to afford the kind of representation that had once made her seem untouchable. A stark, almost dizzying reversal from the woman who'd gavelled Harold into silence at a folding table years earlier. The county eventually appointed her a public defender, and the criminal case moved forward methodically over the following months, built on the same overwhelming evidence Danny had assembled: forged documents, bribery disguised as consulting fees, and clear proof of witness intimidation against my own family. I attended parts of the criminal trial, not out of vindictiveness, but because I felt I owed it to Harold, to Sylvia, to the Reeses, and to everyone who'd stood up against Deborah at real personal risk, to see this through to its final, complete conclusion. Sylvia testified once more, calm and unwavering as always, while the county's handwriting expert confirmed definitively that the notary signature on the amended survey didn't match any authentic sample from that notary's licensed career, closing the last remaining gap in the forgery timeline. Deborah's public defender argued for leniency, citing her lack of prior criminal record, but the prosecutor countered with Sylvia's earlier discovery about Eleanor Whitlock, Deborah's own mother-in-law, and the smaller land dispute years before, establishing a documented pattern rather than a single isolated lapse in judgment. The jury deliberated for less than a full day. Deborah was convicted on all major counts: forgery, bribery, and witness intimidation, with sentencing scheduled for several weeks later, pending a standard pre-sentencing investigation into her background and the full financial scope of her fraud. Word of the conviction spread through the county fast, and this time, nobody in Falcon Ridge Estates defended her. Even homeowners who'd once signed her petition against me now spoke openly about how thoroughly she deceived and endangered the entire community for her own personal financial gain. At sentencing, the judge cited the calculated, years-long nature of her scheme, the forged notary stamp, the bribery, the intimidation of a family simply trying to protect land they'd owned for generations, and handed down a sentence that included both prison time and substantial restitution. The restitution order covered my legal fees, the damage to my fence and cattle operation, and compensation for the emotional toll 9 months of fraud and intimidation had placed on my family. A small but meaningful acknowledgement of everything Deborah's greed had put us through. I didn't feel triumphant when the sentence was read. Exactly. I felt something quieter, steadier, closer to relief. The specific relief of watching a system that had felt slow and uncertain for months finally, deliberately, arrive at the truth and hold someone accountable for it. Falcon Ridge Estates dissolved its original HOA board entirely in the aftermath, reorganizing under new bylaws with stricter financial oversight and mandatory quorum. verification for any future votes. Changes Harold helped draft personally, determined that no future president could ever run the association the way Deborah had. Harold was elected the neighborhood's first official president under the new bylaws, no longer just interim, chosen unanimously by neighbors who'd watched him quietly gather meeting minutes for years and use them, eventually, to help dismantle the very fraud he'd once been silenced for questioning. The Reeses invited Renee and me to a small neighborhood gathering that spring, a modest cookout held in the same subdivision where all of this had started, now filled with legitimately deeded homes and neighbors who genuinely wanted to thank us for how the whole ordeal had ended. I stood at that cookout looking across a subdivision that had once represented 9 months of forged documents, cut fences, and sleepless nights, now just an ordinary neighborhood full of ordinary families, grilling burgers and letting their kids run through sprinklers on a warm Texas evening. Deborah Whitlock began serving her sentence that summer, her name still occasionally mentioned around town, less with anger now and more with the particular, exhausted disbelief small communities reserve for someone who'd fooled everyone right up until the moment the paperwork finally caught up with her. Marcus Doyle's development company folded within the year. Unable to secure financing after 2 separate fraud scandals became public record. A quiet professional collapse that felt, to me, like its own kind of justice for a man who'd built his career exploiting exactly this kind of scheme. My grandfather's rusted gate still stands at the edge of what used to be disputed land. The brand welded into the ironwork now framed by a paved subdivision street instead of open scrub. A strange but fitting monument to 60 years of ranching that no forged survey ever managed to erase. Renee likes to say the whole ordeal taught our family that patience and paperwork win fights that anger never could. And she's not wrong. Though I'd add that it also taught me how many good, honest people are willing to stand up once someone finally gives them the evidence to do it with. The 40 acres are legally, permanently mine now, recorded properly at last in the county clerk's office, filed correctly this time under Sylvia's careful watch, closing a chapter that started with a clipboard at my fence line and ended in a courtroom 9 months later. I still run cattle across part of that strip. The same rusted gate swinging open every morning the way it has for generations, though these days it opens onto a legitimate subdivision full of families who bought their homes honestly. For me, after everything Deborah tried to take got handed back where it belonged. Some nights I think about that first morning, watching bulldozers tear into land my grandfather cleared by hand, and how certain Deborah seemed that finishing those houses fast would settle the matter in her favor before anyone could stop her. Instead, every finished roof, every framed wall, every driveway poured in that reckless final rush became the very evidence that handed her entire scheme over to the family she'd tried to steal it from. Proof that sometimes the biggest mistake isn't starting the fight, is finishing it too fast to think clearly. Harold still keeps meticulous meeting minutes at every HOA gathering, a habit nobody teases him about anymore. And Sylvia still greets me warmly whenever I stop by the clerk's office, both of them quiet reminders that ordinary diligence, kept up long enough, eventually outlasts even the most confident fraud. The Reeses planted a small garden along their new property line last spring, and when I drove past and saw it, I felt something close to peace. The same 40 acres that once represented 9 months of fear and forged paperwork, now just an ordinary neighbor's yard, growing tomatoes in the Texas sun. Deborah Whitlock is still serving her sentence as I write this. Her name mostly a cautionary tale now around Comfort, Texas, told to newer HOA board members. as a warning about what happens when someone mistakes a volunteer position for personal ownership over land and neighbors that were never truly theirs. As for me, I still wake up early, still check fences before breakfast, still run cattle across the same stretch of land my grandfather worked with his own 2 hands, 40 acres heavier in paperwork now, but exactly where they always belonged, right here on the Colton Ranch. People still ask me sometimes if I regret how long the fight took. 9 months of surveyors, forged documents, cut fences, and courtroom hearings, before it finally ended the way it should have from the very beginning. I tell them the truth. I regret none of it, because somewhere in those 9 months, a quiet county clerk, a retired schoolteacher, and a frightened young couple who just bought their first home all found the courage to stand up against someone they'd been taught for years to simply avoid, rather than confront directly. That courage mattered more, in the end, than any single piece of paperwork Danny filed or any ruling the judge handed down. It was ordinary people, refusing to stay quiet, who turned a stolen boundary line into a story about what happens when a community finally decides enough is enough. Deborah built her entire scheme believing nobody would look closely enough, question loudly enough, or hold the line long enough to stop her before the houses went up. She was wrong on every count, and it cost her everything she'd tried so hard, so dishonestly, to gain. I think about my grandfather sometimes, standing at that same rusted gate decades ago, driving fence posts into ground he'd worked hard to earn, never imagining a subdivision would rise beside it, let alone that his grandson would have to fight so hard just to keep what was rightfully theirs. I like to believe he'd have appreciated the ending, not the courtroom drama or the headlines, but the quieter part. Cattle still grazing along that boundary line, the brand still welded into the gate. Proof that some things, built honestly and defended patiently, simply don't give way to greed. Renee framed a copy of the final court ruling and hung it in our hallway. Not out of vanity, she says, but as a reminder for our grandkids someday, that the land under their feet was fought for honestly, against someone who tried very hard to take it dishonestly instead. Falcon Ridge Estates, under Harold's steady new leadership, has become, oddly enough, a genuinely pleasant place to live, full of neighbors who look out for one another now in ways they never quite managed under Deborah's rigid, fearful reign over every folding table meeting she once controlled. The Reeses invited us to their daughter's birthday party last month, held in their backyard that sits, technically, on what used to be disputed Colton land, and watching kids chase each other around a bounce house felt like the truest, most ordinary kind of victory this whole fight could have produced. I sold most of the finished Phase 3 homes at fair market value, keeping only a handful for future family use. A decision Danny said made the whole resolution cleaner and more defensible. Though honestly I just wanted good families in those houses instead of empty monuments to someone else's fraud. Every so often a new neighbor stops by the ranch gate, curious about the story they've heard secondhand. And I tell it straight, no exaggeration needed, because the truth of what Deborah tried to do, and how thoroughly it backfired, is dramatic enough entirely on its own. Marcus Doyle reportedly left the state after his company folded, chasing new development deals somewhere out west. Though Danny says his name now carries enough baggage in Texas real estate circles that few serious partners will touch a project with his fingerprints on it anymore. The county quietly updated its survey archive procedures after our case. adding stricter verification steps for any amended boundary filings. A small bureaucratic reform. Sylvia says has already caught 2 other attempted discrepancies since. Neither as serious as Deborah's. But proof the system learned something from what happened here. Harold sent me a copy of the new HOA bylaws once they were finalized. Quorum requirements underlined in bold. Financial disclosure rules tightened considerably. Small institutional scars from a wound nobody in Falcon Ridge Estates wants to risk reopening under any future board president. Gary Fenn eventually left the contracting business altogether, taking a maintenance job at a lumber yard 2 counties over. A quieter, more honest living than the one that had briefly promised him easy money for cutting corners on land that was never his to build on. Renee and I still walk the disputed strip most evenings. Past the rusted gate. Past the neighborhood that grew out of someone else's greed and became, eventually, an honest place anyway. Cattle grazing calmly along a boundary line that no longer needs defending from anyone. Deborah's sentence includes a lengthy period of supervised release once she's out, along with a permanent restriction from serving on any homeowners association board in the state of Texas. A small, specific consequence that Harold said felt almost poetically fitting given how it all began. In the end, the land my grandfather cleared by hand outlasted every forged document, every bribed vote, and every reckless bulldozer sent to steal it, standing exactly where it always stood. Boundary finally settled, gate finally quiet, cattle finally grazing without anyone watching from a car down the road. Deborah Whitlock built 100 houses on my ranch without asking, certain that finishing them fast would be her victory, and instead handed me, through her own greed and haste, more proof and more property than any lawsuit alone could ever have won for my family. That, in the end, was her biggest mistake. Not starting the fight over 40 acres of scrub grass and cattle trails, but finishing it, roof by roof and wall by wall, before the truth ever had the chance to catch up with her.